appeal in the matter of Muller UK and Ireland Group LLP, Muller Dairy UK Limited, Robert Wiseman and Sons Limited, TM UK Production Limited, and the Commissioners for HMRC.
Yes, Mr. Speaker.
Lords, my lady, good morning. I appear in this matter with my own friend Mr. Fitzpatrick for the Muller Appellants, and my own friends Mr. Titmarsh, Mr. Ansell, and Mr. Rees appear for the respondent commissioners.
Yes.
You have been provided with a core bundle and an authorities bundle in paper and in electronic form. I propose to use, at least initially, the electronic form, but if it's more convenient, I can give the page references to
I'm
the
afraid
paper.
I'm a dinosaur. I use the paper one.
Well, I'm trying very hard not to be.
I'm afraid.
There is a wrinkle in that almost inevitably these days, the pagination is different.
Usually happens.
Because there were some insertions into the authorities bundle that are now paginated.
We'll find our way around, don't worry.
Well, if it helps, there's a 17-page difference beyond page 200.
Right.
And I'll try and give you both.
Okay. I can tell you that we've read both decisions of the tribunals and we've read the skeleton arguments.
Lord, I'm very grateful. So as the court will have seen, this appeal raises three short, nice points of statutory construction. There's the application of section 882 in the context of part 17 of the Corporation Tax Act. That's the first. The second is the commencement rule in the Finance Act 2016. And the third is the effect of the drafting error in the Finance Act 2016. My submissions will be in 5 parts. Firstly, to look very quickly at the relevant principles of statutory construction. Secondly, to look at the basic operation of Part 17 and Part 8 of the Corporation Tax Act to set the scene. Thirdly, to look very briefly at the relevant facts here. And then the fourth part, but my first substantive part, is to tackle Part 8 and Section 882, the first issue. And then my fifth topic will be the Finance Act 2016 and the second issue. I anticipate, if left to my own devices, that I'll finish about 1:45. That would leave my learned friend roughly 2¼ hours, and then that would leave me perhaps 10 or 15 minutes by way of reply.
Fine.
So that's my aim. Relevant principles of statutory construction are common ground. The court is required to adopt a purposive approach to the interpretation of the relevant language, looking at the language in its proper context, and with the help of such external aids as are appropriate and helpful. However, the court will need to bear in mind, will no doubt have in mind, that ultimately it's a matter of looking at the words that Parliament has used. Now, we cited 2 authorities in the skeleton. Perhaps if I just give you the references, because I anticipate they'll be very familiar to the court. But the most recent exposition of the relevant principles in the Supreme Court is in the 4 Women Scotland case, and in particular paragraphs 9 to 12, which in the paper version of the bundle begins at page 616. And this is Lord Hodge, Lady Rose and Lady Simler. Paragraph 9, paper version, page 616, begins the general approach to statutory interpretation. Page that the court will have seen those principles before, because the court refers back to Spath Home and the R and O case. So all very familiar stuff.
R and O seems to be the best starting point nowadays. I tend to find that it was very largely incorporated in what they went on to say in the 4 Women Scotland case.
My lord, yes, and more recent decisions in the Supreme Court have just harked back to the summary and R and O. So yes, we endorse that. One other point just to make under this heading, we have referred in the skeleton argument, it may just be helpful to turn up Williams and Bank of Nigeria and Lord Neuberger. This is at page 368 in the paper bundle, paragraph 72. The paragraph begins, given the unambiguous way in which, between letters E and F, His Lordship identifies the court's function, determining of the meaning of the words used in the statute, paying attention to context and mischief, his lordship refers back to Black Clawson and Lord Reed. We are seeking the meaning of the words which Parliament has used. I don't understand there to be any difference of principle between the parties as to those relevant principles. So those are the relevant principles. That's my first heading. Second heading is the basic operation of Part 17 and Part 8 of the Corporation Tax Act. Part 17 is the part of the Act that deals with partnerships. Putting LLPs aside for a moment, the court will be well aware that partnerships are not separate legal entities. So that raises the question of whether, for corporation tax purposes, we should look at a partnership or through it. And by and large, the general rule in the Corporation Tax Code is that you look through the partnership to the members, such that a partnership is, in the jargon, transparent. And that is the effect of sections 1256 through to 1258 of the Corporation Tax Act. And you should find that at page 165 of the Authorities Bundle, first volume. So 1256 identifies that the parties giving special rules for partnerships, that's 1256.1, 163. 1257 is the general provision. So persons carrying on a trade in partnership are referred to as a firm. 1257.2, whilst there's a reference to trades, it also applies to partnerships that are carrying on a business that are not a trade. No magic in the word trade. And then 1258, unless otherwise indicated, a firm is not to be regarded for corporation tax purposes as an entity separate and distinct from the partners. I'm going to come to 1259 in a moment, but that same approach is also adopted for limited liability partnerships because they are treated as if they were firms, and thus the rules in 1256 to 1258 that we've just seen apply to LLPs just as they do to English general partnerships. And that's the effect of section 1273, which is at page 175 in the bundle. So again, all of that's common ground. Companies are obviously liable to corporation tax on their profits, but the code has to make provision for corporate members of partnerships. Now, the activity that a company carries on outside the partnership will be computed, the profits of which will be computed in the ordinary way. So if it's got receipts of 100 and expenses of 80, it's got a corporation tax profit of 20. But the profits that it makes from the activity that it carries on in partnership requires us to identify the profits of the partnership activity and then to allocate those profits to the partners in the way that they've agreed. And then you can tax the profits in the hands of the partner. And so if you've got an activity outside a partnership, you compute that of 100 minus 80. But you also have to factor in, when you come to do your corporation tax computation, the share of the profits that have been allocated to you for your partnership activity. Now, the code also has to recognise that you might have a corporate member of a partnership and an individual member of a partnership. And individuals are liable to income tax and not corporation tax. And the code also has to recognise that you might have a UK resident member of a partnership, and it might be a non-UK resident member of a partnership. So you've got 4 possibilities. And the Act deals with that by the provision that's in section 1259, so page 164 of the paper bundle, calculation of firms' profits and losses. So 1259(1), this section applies if a firm carries on a trade and any partner in the firm is a company. So this is dealing with a world in which you have corporate members. There are equivalent provisions in the income tax code dealing with a world in which you've got individual members. So they're not in the bundle, but they are materially the same. 1259(2) provides that the amount of the profits of the trade is taken to be the amount determined in relation to the partner in accordance with subsections 3 or 4. And 3 deals with the world in which your partner is UK resident, and 4 deals with the world in which it's non-UK resident. I'll come back to 1259(3) in a little while. But the purpose of these rules is to allow us to compute the partnership's profits on a certain assumption, then to divide those profits in accordance with the agreement between the members, typically in a partnership deed. So if the partnership profits are 100 and I am a quarter share partner, then the profits that are treated as mine are 25, and they are added to the profits of any activity I carry on outside the partnership. And then I pay tax on perhaps 125. Now, what about the nature of section 1259? There's a slightly arid debate about whether section 1259 is a deeming provision. That's not a term of art. It rather depends on what the statute requires.
Well, there's a lot of pretending going on here, isn't there? You start with an LLP, which is a body corporate. You pretend it's a partnership. And if it's got a corporate member, you then pretend that the partnership's trade is being carried on by a company.
Yes.
Now, whether you call it deeming, pretending, a certain assumption was the word you used, doesn't really matter, does it?
Nope. Now, I'm going to say it's not a deeming provision in the sense that it deems X to be Y. You're not changing the nature of the entity. You're not deeming the partnership to be the company or a company. There's a statutory direction or a statutory assumption that the trade of the partnership is carried on by a UK resident company.
Yeah.
But what 1259 doesn't do is to treat the actual control attributes of the LLP to be those of the UK resident company.
Please would you say that again, Mr. Beagle? It doesn't treat
What I'm going to call the control attributes. Doesn't deem the actual control attributes of the LLP to be those of the statutorily directed UK resident company. This is getting to the heart of the debate between us, and I'll come back to what I say about it. But just to identify at this stage that there is a statutory direction in 1259, and we have to look very carefully at what that statutory direction is.
Yes.
Yeah. Now, the purpose of 1259, there's no great mystery about it. It's to ensure that a company's share of the LLP's profits are computed using corporation tax rules, not income tax rules. And to pick up a point I made a moment ago, because you could have individual members and corporate members, resident or UK resident, there are in effect 4 different sets of rules you might apply in determining the profits of a partnership. And they don't necessarily produce the same answer, because the corporation tax rules are not exactly the same as the income tax rules. So if you've got a partnership that's got 2 corporate members and 2 individual members, you have to do this exercise for each of the corporates and each of the individuals, but the profit figure you arrive at the end of each of those exercises is not necessarily the same. It's highly likely to be the same or very close, but it's not necessarily the same. Now, we relied below on what the Upper Tribunal had said in the Bluecrest Cayman case, about the true effect of section 1259. And it was said against us by my learned friends and by the tribunals below, well, Blue Crest is about something different. And it is. It was ultimately a debate about whether, if you are a partnership that is a partner in a partnership, are the members of the top partnership necessarily members of the bottom partnership?
Yes, I remember.
The court said no. However I put it, the answer was no. But I wasn't in the Upper Tribunal, but in the Court of Appeal certainly. But what the Upper Tribunal helpfully did in Blue Crest in the Upper Tribunal was to identify what we say is the true purpose and effect of section 1259. And it's in the authorities bundle at 511. Paragraph 161. So you should find at page 511, paragraph 161. And we, in particular, place reliance upon what the Upper Tribunal had to say at paragraph 161, sub 3. So they say at letter D on that page, the subsection is not expressed to be a deeming provision, and it applies by giving a statutory direction to calculate the profits of the company as if a non-UK resident company carried on the trade. We say that's an accurate summary of what is the effect of section 1259. No more, no less. Now, let me accept again that the debate in Cayman was about something else. And that particular point wasn't addressed when Blue Crest Cayman came to the Court of Appeal, but we do say the Upper Tribunal got that right. So it's a statutory direction to determine what the profits would be if the trade actually carried on by the partnership, the LLP, were, in the factual world, carried on by a UK resident company. Now we can see that that is the limited effect of 1259. If we go back to page 165 in the authorities, 165. This is still part 17. Just to note, over the page, over a couple of pages, at 167, part 17 also deals with accounting periods. Now, we're not concerned with the application of 1261, but note 1261 subsection 1, in this part, references to an accounting period which carries on a trade are to a period that would be an accounting period of the firm if the firm were a company. So that is going one conceptual step further. It's actually changing the nature of the entity. So your counterfactual there is not that the trade is carried on by somebody else, but that the firm is a company. And the same approach is adopted, again, different provision, different reason. But if one looks on at 1267, which should be page 170 of the bundle, and this is to deal with adjustments that can arise on a change of accounting basis. So again, the detail doesn't matter, it's not relevant to this appeal, but you make adjustments when you're dealing with a firm, they are to be calculated, this is subsection 1, as if the firm were a company, a UK resident company. So contrast between the statutory direction in our case and the statutory direction in those cases. Second point to note about 1259 subsection 3 is that the trade is carried on by a UK resident company. It's an indefinite company, it's not the company. It's indeterminate in the sense that it's just a UK resident company, any company. And we are not told anything more about it. So you're not told whether it's got share capital or it's limited by guarantee. You're not told whether it's incorporated under the Companies Act or it's an unincorporated association. All of those things are capable of being companies for corporation tax purposes. We're not told anything else about it. Now, we're not told anything else about the company because you don't need to know anything else to give effect to what section 1259 subsection 3 requires. What the provision is designed to do is to identify the rules to be used in computing the profits of the particular partner. So you're directed to compute the profits as if the trade were carried on by a company, so as to engage the corporation tax rules and not the income tax rules. And this is where we part company with my learned friends. If you have their skeleton to hand, it's in the core bundle, page 248. And in particular, it's paragraph 21. Five lines down.
Just speak up, which paragraph?
Paragraph 21.
20.
Page 248, internal page 8.
Yes.
Sentence begins 6 lines down. So you invite the court to either mark it or underline it. The purpose of 1259.3 and that fiction, sort of fiction that's produced by 3A, is to provide for a firm's profits to be calculated in line with corporation tax rules. Tick, we agree. And to disallow deductions engineered by transactions between entities under common control. That is no part of the purpose of section 1259. What my learned friend's case relies upon is this court accepting that you can discern some purpose from section 882, which we don't accept in any event, for reasons I'll come back to. They're proceeding on the basis that you can discern some purpose from section 882, and then you can find that in the purpose of section 1259, and you can't. The purpose of 1259 is to enable the computation of profits for corporation tax purposes, applying such provisions of the Corporation Tax Code as are relevant to that exercise. And that, of course, includes applying section 882. But there's nothing in section 1259 which requires a particular outcome to the application of section 882. So the crux of the debate between us, and where we say, with respect to my own friends, just go wrong, is in that sentence in paragraph 21 of their skeleton.
So if you've got this unidentified notional company carrying on the trade of the LLP, which we're pretending is a partnership, what is it in section 1259 that tells you when this notional company acquired the intangible assets used in the trade?
I'm going to come to that, Muller. You've got to assume it carries on the trade of the LLP And that necessarily includes that it holds the intangible assets to which we are going to apply Part 8.
Oh, absolutely. But why does it mandate any assumption about when those assets were acquired?
Can I come to that in just a little while?
Yes,
But
by all
I hear
means.
my Lord's question, but I'm going to say that it's part of the assumption that it's carrying on this trade, that it acquired these assets on this date. It's part of the directed assumption. Now, that's part 17, the provision dealing with partnerships and how do they fit into corporation tax. Part 8, I anticipate the court's ahead of me on this. Prior to 2002, the tax treatment of intellectual or intangible property was frankly a mess of income tax and capital gains tax provisions and some old and rather unsatisfactory case law dating back to the turn of the century in the 1920s. It was not at all clear how the UK tax code dealt with intellectual property, and it was no longer suitable for the modern world. Finance Act 2002 introduced the single uniform code, which becomes Part 8 of our Corporation Tax Act. It applies to intangible assets, so trademarks, copyrights, brands, goodwill, etc., where they are in effect a fixed capital item in the business. So you're not trading in them, they're a fixed asset. Hence this notion of an intangible fixed asset. The code in Part 8 typically works off the accounting treatment because the accountants have solved a lot of these problems, and so the Corporation Tax Code can piggyback on the work and the thinking of accountants. Provision is made in the code for acquiring IFAs, intangible fixed assets, and for realizing them. Relevantly for this appeal, provision is made for amortization. So if you have an asset that you are amortizing in your accounts, so it's got an original account value of 100, you're writing it down over a 10-year basis. The code provides that where you have an accounting debit for amortization of intangible property, you get a tax deduction for that amount. And that's the effect of sections 711 to 713, and then sections 726, 729, and 742 of Part 8. It may just help to see those, though I anticipate the court has appreciated the effect of them. But it's in the authorities bundle beginning at page 13, first volume. So section 11, overview of the part. Talking about the meaning of intangible fixed assets. Over the page, 712 is a definition of intangible asset. 713 is the definition of intangible fixed asset. And then relevantly for our purposes, it's section 726 on page 19. It provides for debits to be brought into account. And then 1b, little Roman 1, writing down on an accounting basis. So 726 1b Roman 1 introduces section 729, and then 729 gives a debit where you have an amortization debit in your accounts. And that's what was claimed here. It was amortization debits that were claimed. Just to note, we don't need that. So that's sections 726, 729. Some aspects of Part 8 depend on whether the transactions involve related parties. And that's a defined term in section 835, which which is page 68 of the authorities bundle. If you have page 68 headed Chapter 12 Related Parties, 834 is the overview. 835 defines a related party. So if both parties, so you're here concerned looking at 8351, it explains when a person A is a related party in relation to a company B. So B is a company, and then you have to ask, is A also a company? And if A is also a company, then you look to subsections 2, 3, and 6. So 2 is where they're both companies and one's got control of or a major interest in the other. 3 is where they're both companies and they're under common control of a different person. And subsection 6 is where they are both members of the same group. But those related party rules work where both A and B are companies. Now, just to finish off that part of 835, subsection 4 turns off control in certain cases, and subsection 7 to 9 deal with a case where there would otherwise be a relevant relationship but for insolvency. But once you strip away subsection 4 and 7 to 9, you have rules that look to the nature of the relationship between parties where they're both companies. Now, one company will control another where the notion of control in 836 is met. That's page 69. Control means the power of a person to secure that the company's affairs are conducted in accordance with the person's wishes, familiar provision by the holding of shares or the possession of voting power, or as a result of powers conferred by the Articles of Association or other document regulating the company or any other company. So a familiar test of control. Major interest, so you might have a major interest, 837, that applies where the person and one other person together have control. So you've still got to satisfy control, but the rights and powers by means of which they have such control represent, in the case of each of them, at least 40% of the total. So that's dealing with a world in which you've got a 40% controller and another 40% controller, so they're said to have a major interest. And then in applying the notions of control and major interest, you also have to apply the rules in sections 838 and 839. And 838 extends the rights and powers by which a person might have control, again in a familiar way, by looking at rights you might be entitled to acquire or rights that might be exercised on your behalf. I paraphrase, but you'll see the effect of 838. And then 839 deals with rights held jointly. So all of those provisions are parasitic on finding that there is control in section 836. And the rules on control in section 836 require you to find that both company A and company B are, parties A and B are companies. Now, this regime that was new in 2002 needed a boundary rule to divide between the old world and the new world. And that boundary rule is section 882, which is at page 89. And we are here concerned with section 8821B. I'm going to look at this in a little more detail in just a little while. But we are here concerned with the acquisition by the company on or after that date, so 1st of April 2002, from a person who, please underline, at the time of the acquisition is not a related party. So in 8821B, you are concerned with the nature of the relationship at the date of acquisition. So that's the broad effect of Part 8. That's my second heading. The third heading in my submissions is this case. Well, the factual position is set out below and can be shortly stated. Muller is an international dairy and food business based in Germany. Muller first had operations in the UK in 1987. They expanded a little in 2011. And the key step in the UK was the acquisition of the Robert Wiseman milk business in 2012. In consequence of those steps, there were 3 companies in the wider Muller group. That's Muller Dairy UK Limited, Robert Wiseman and Sons Limited, and TM UK Production Limited, so 3 of our appellants. Each of them had UK operations. And as part of those businesses, those 3 companies also owned intangible fixed assets. And in 2013, 1st of July 2013, the businesses and the relevant IFAs were transferred by each of those 3 companies to the LLP, the transfer of the trades and of the assets happening on the same day. And it's common ground that that was an entirely commercial transaction done to achieve particular business efficiencies in the UK.
Is there any finding of fact to that effect?
Not directly.
I rather wondered whether there was.
We know this. There is a provision in Part 8, which I haven't shown you, it's in the bundle, is Section 864, that allows the revenue to challenge a particular treatment under Part 8 if they think the transaction is a tax avoidance transaction. And in this instance, the revenue contemplated a challenge based on Section 864, but abandoned it before we got to the first tier hearing, having satisfied themselves that this was not a tax avoidance transaction. So there is, as my Lord observes, no direct finding to that effect because it just wasn't an issue before the first tier.
Thank you.
Now, to set the scene, we have here a transfer to the LLP after April 2002. That transfer included intangible fixed assets, which came to be held by the partnership. And we are directed in the years after 2013 to compute the profits of the LLP as if its trade were carried on by a UK resident company, so as to determine the profits chargeable to corporation tax in the hands of the corporate members. The companies have claimed in the computation of those profits a debit under Part 8 for the writing down of the intangibles. Question on this appeal, are they entitled to do so? And that depends on Section 882. So Then we turn to my fourth heading, Part 8 and Section 882. Can we go back to Section 880, which you might have open at page 88 of the bundle. Sorry, 86 of the bundle. This is Chapter 16, overview of chapter 880. Little a, this chapter sets out a general rule limiting the application of this part to certain assets, see section 8821, application of this part to assets created or acquired on or after 1st April 2002. So you're told there what's the broad purpose of section 882. (881) tells us that when you see further on in the part a reference to a pre-FA 2002 asset, you are colloquially looking at an old world asset, not a new world asset. And then 882 provides the general rule, this part applies only to intangible fixed assets of a company, the company. And if one runs an eye down little a and b and c, the first question is, are these assets created by the company or acquired by the company? If they're created by the company, then you have to address 8821 little a and ask, when were they created? And there are rules further down the code which tell you when assets are treated as being created. Now, we're not in 8821 little a, but the first question is created or acquired. If the assets are not created but acquired, you're then within little b or little c. There are in effect two sets of conditions, the application of which depends on whether you acquire from a related party or not. If you acquire from a related party, then you're only in the new regime if you acquire on or after the 1st of April 2002 and you fall within case A or B or C. That's the effect of 8821 little c. If you acquire from a related party, there are two hurdles to cross. There's the date of acquisition, and there's the satisfaction of case A or B or C. Now, we're not ultimately concerned with cases A, B, or C, but they apply where you acquire from a related party for whom the asset is an IFA within the regime, say, or you acquire from a third, but you acquire from a person who acquired it from a third unrelated party, that's case B. And case C is where the asset's created after the 1st of April by the vendor or somebody else, and then you acquire from that person.
Could you just explain why we're not concerned with cases A, B, and C?
If I'm positing, my lord, that you're acquiring from a related party, and if you are an acquisition from a related party, then you follow little c, and there are in effect two hurdles. One is the date of acquisition, and the second hurdle is meeting either case A or B or C.
Well, I follow that. That's what the statute says. But why are we not concerned with that?
Well, the question in this appeal is the acquisition from a related party? And if the answer is yes, then we would be within 1C, and my clients would not be entitled to a debit.
Because they're not within case A, B, or C.
Correct. But my lord's question is, in effect, that's the appeal.
Well, I'm asking the question because of the way that you are approaching section 1259. Your argument is we know nothing about this national company. So why are you singling out 8821C as being the bit we're not concerned with? On your argument, we're not concerned with any of it, are we?
Well, no, my lord, we are.
We are, all right.
Your Lordship will give me another 90 seconds and I'll draw those threads together.
Yes.
So 8821 little c looks at a world in which you have acquired from a related party. And there are two conditions, two hurdles. 881 little b looks at a world where you've acquired from somebody who's not a related party. And then the only condition or hurdle is the date of acquisition. So the question on this appeal is whether here there's an acquisition from a person who is a related party or an unrelated party. We know the acquisition here was by the LLP. We know we don't apply Part 8 to the LLP itself because you look through the LLP. But we also know that you have to apply Part 8 as part of determining the profits of the LLP as if its trade were carried on by a UK resident company. So the refined question for the court on this appeal is whether the UK resident company that we assume is carrying on the trade acquired the IFAs from a related party.
Well, let's go back to a question I put to you earlier. The question is whether the assumed company acquired the IFAs from a related party on or after the 1st of April 2002.
From a party that may or may not be related, but in either instance on or after 1st of April 2002. Because the acquisition after 1st of April 2002 is a common hurdle whether you're in 8821B or 1C.
Yes.
Now, in order to test that question about acquisition from a related party or not a related party, we have to ask whether the transferors had control of or held a major interest in or are members of the same group as the UK resident company. So you have to apply section 836 on control and section 837 on control and major interest, or you have to ask whether they are members of the same group. And group, just for your note, is defined or explained in section 765, authorities bundle page 34. But to be in a group, you have to be a 75% subsidiary and an effective 51% subsidiary, both of those concepts being expressed by reference to share capital. So can the real world relationship between the members and the partnership be ascribed to a UK resident company? And if you can ascribe the real world characteristics of the partnership to the statutorily directed UK resident company that carries on the trade, then the parties would be related. We accept that common ground. The question is, can you do that? We say no. Parliament has not provided any rule to that effect. So there's no express provision directing that the actual relationship between the members and the partnership shall be used to determine if a UK resident company acquires from a related party. No express rule to that effect. Can it be implied from the statutory direction to compute the profits as if the resident company carries on a trade? We say no, there's nothing implicit in that requirement, that the actual relationship applies for the purposes of determining the related party question. Putting that the other way around, you need to identify, for corporation tax purposes, the profits of the partnership in order to attribute them to the corporate members. You need to apply the corporation tax rules in carrying out that exercise. That includes section 882, we agree. You have to ask if section 882(1)(b) is met. We say it's not. There is no relevant control relationship or major interest relationship between the transferor and the statutorily directed UK resident company. So we say we've asked and answered the section 882 question, we've applied section 882, and the conclusion is you've determined that there's an acquisition from a party that is not related, because there is no provision that ascribes to the statutorily directed UK resident company any aspect of the real world relationship between the parties. And if that's right, you've got an acquisition from somebody who's not a related party, then you still don't automatically get into Part 8 because you've still got to show the acquisition is after the 1st of April. I'll come to that, just my Lord's question in a moment. I anticipate that I need to address that.
Why do you assume there's an acquisition? All you know is that this, on your argument as I understand it, all you know is that this notional company is carrying on a trade using the Muller trademark, let us say. But you don't know whether that notional company created the mark,
It's
acquired the mark, is licensed to use the mark. You don't know anything about it.
well, the statutory direction is that the trade actually carried on by the LLP is assumed to be carried on by the UK resident company.
Well, the trade is selling yogurt under the Muller brand.
But under the Muller brand,
Yes. So it's got the mark. It's using the mark.
it has the trademarks, it has the intangible assets.
Yes. But why? How do you know whether it's created them, acquired them, or done anything else with them?
Well, because you're directed to carry on that trade, you have to apply this rule the day after the acquisition. So this happened on the 1st of July 2013. We need to know this answer, or the answer to this question, on the 2nd of July 2013. So you ask, and the question you ask is the same on every day. This ran for 5 years before the amortization ran out and the assets have been written down. You have to ask that question on every day. And so on the following day, you're directed to assume that the trade carried on by these companies on day 2 is the trade that's carried on. Sorry, the trade that's carried on by these members on day 2 is the trade that's carried on by the UK resident company. And that necessarily requires you to assume that the assets, the intangible fixed assets, are owned by the UK resident company and were owned by virtue of the acquisition on the day before. It's part of the statutorily directed assumption. Now, just coming back to where I broke off, we say that applying 882 in that way, you have asked the 882 boundary question, you've answered the 882 boundary question, you've just not answered it in a way that the revenue like. And that's why they say in paragraph 21 of their skeleton argument, because they don't like the result, they infer that there's a purpose in 882 to stop what they call engineered transactions. Brackets, we are not an engineered transaction. And we say they can't spell that out of the purpose of 882. It's just providing a boundary rule between the old world and the new world. But you certainly can't transpose that purpose in 882 to section 1259. 1259 has got nothing to do with the purpose of 882.
Can I just ask you where the burden of proof on your case lies on this issue? I mean, somewhere in your skeleton argument, you seem to refer to HMRC being unable to establish that such and such is the position. Whereas, I mean, the conventional position is that the burden lies on the taxpayers of this place. An assessment. I don't suppose you're quarrelling with that general.
I am not. I am not.
So technically, I mean, it's not. This is not as though we're dealing with a situation where HMRC is trying to apply an express anti-avoidance provision, as you've explained. There, the burden of proof would no doubt be on HMRC to make the running, but we're not in that situation. So this is, I mean, this may ultimately not matter at all. But I just want to be clear. There's no disagreement about where the burden lies.
Nope. Quite accept that.
Thank you.
But the question, my lord, is this an acquisition from a related party or not?
Absolutely.
I have to persuade the court that the answer is not.
Yes.
I'm not seeking to run away from that obligation. But it is binary. It either is or it isn't. We're either in 1B or 1C. And if we're in 1C, I accept that we don't get home. But if this court is going to conclude that this is an acquisition from a related party, we need to work out why that is right. And is that the product of the statutory direction in 1259? We say no. So there's no problem in our view of the world with applying this legislation. We do ask and answer the 882 question, and we end up in a world where within 882 1B and not 1C, but there's nothing inherently objectionable in that if you have concluded that it's an acquisition not from a related party.
Is that right? I wonder, just following on from my lord's question, taxpayer claims a tax deduction equivalent to the amortization write-down.
Yes.
And HMRC say, well, what entitles you to that write-down, that tax deduction? And you say, well, it's section 882 that entitles me to do that. All right, which bit of section 882 are you in?
1B.
How do you establish that?
We are not an acquisition from a related party. So there are only, the cat is alive or dead. There are only two possibilities. And it's either from a related party or it's not. If it is, we're within 1C and we don't qualify. If it's not from a related party, then we're within 1B.
So you say, well, we this notional company, we acquired the IFAs, revenue say when, and you say after the 1st of April 2002.
1st of July
How
2030.
do you establish that?
Because that's part of the statutorily directed assumption to carry on this trade.
Next question, who did you acquire them from? Don't you have to say, well, we acquired them from X or Y?
The only statutory question is not who did you acquire them from, but what is the relationship?
All right, well, I'll put that question. What is the relationship between you and the transferor of these assets? And you say, well, we don't know.
Parliament hasn't told us.
So we don't know.
We don't know.
So we don't know whether you're in B or C.
No, we know that we're not from a related party because we don't meet 836, 837 and 838. Now, my lord observed by email yesterday that we might look at the Bilter case.
Well, I just wondered because that was to do with assumptions of
It's a
placing attributes on companies. It's a very different context, obviously.
different context. There is a parallel, there is an analogue, and I'll come to it in just a second. But what was interesting about that case, ultimately, because the Supreme Court said my lord was right, was that there was a question of burden of proof. Who had the claimant companies proven what would have happened in the world where the company had been restored to the register, or had never left the register, to be more accurate. And my lord said, well, ultimately, that's a question, a Section 32 Limitation Act question, that you have to answer on the facts, making the statutory assumption. And because they'd failed to address, or certainly to lead sufficient evidence, they lost on the burden of proof.
Yeah.
Supreme Court said, yes, we agree with that. But there's no analogue with this case, because in the Bilter case, Section 32 asked you to determine whether and when somebody could have been aware of the fraud. And that's clearly a factual matter. But here the relevant question is just a question of law. Did you acquire from a related party or not? Yeah. You have copies of Bilter, but the thrust of the argument in Bilter was the claimant companies said a series of things. One is you can assume that it was the actual directors who were up to their eyes in the fraud. And my lord said, well, you can't assume that because that's not what you're directed to assume. The other possibility was you assume ordinarily competent directors, so hypothetical competent directors, and my lord said, well, that's not the product of the statutory direction. But the other possibility was you assumed no directors. And my lord said, well, that's not part of the statutory assumption, and the Supreme Court in effect agreed with all of those, although one of the arguments was dropped in the Supreme Court. But the answer in that case, given that the statutory direction didn't tell you anything other than that the company had never left the register, was to apply Section 32, which asked in effect a factual question. And the reason Bilter is a useful parallel is it engages the same sort of debate as this appeal. But the reason it's no direct help in arriving at an answer here is because my lord decided, the Supreme Court agreed, that Section 32 in effect asked a factual question that you'd answer on the evidence.
Yeah.
And Section 882 is not that case. I can come back to Bilter if relevant, but the particular observation maybe my lord had in mind is, I'll just give you the reference. It's paragraph 130 in my lord's judgment, which is recognising the limits on the Fowler deeming. Paraphrase, but what my lord was saying is you have to very carefully identify the scope of the statutory direction. No further, no more, no less. And that was something that the Supreme Court agreed with at paragraph 79 in the Supreme Court.
I mean, obviously, it's absolutely critical in this case to answer the question what it is that the deeming provision, if I'm allowed to call it that for the moment, requires. Am I right? It doesn't necessarily require an express answer in the sense that if it's all a question of construction. So you may find it implicit in the statutory scheme read as a whole, and in order to produce a sensible result, one is entitled to adopt such and such a construction, even if it's not expressly spelled out by Parliament. Is that right?
I accept that. And that's why I prefaced the remarks I made perhaps 15 minutes ago by saying, well, let's look at, is there any express provision to introduce the actual control characteristics.
Exactly, but you weren't thereby implying the provision necessarily has to be express. It's
No.
always a question of construction.
My lord, yes, my second proposition was, is there anything implicit that you can spell out of section 1259? And I say no. Because you can answer the application of the Corporation Tax Code here in particular, section 882, on the basis of the statutory direction as it appears on the face of the statute. You don't need to go any further in order to answer the boundary question in section 882.
Put the point another way, you say it's not an inevitable consequence of the deeming that the notional company has acquired its IFAs from a related party.
Correct. You can answer the 882 question without making that further assumption.
But again, so, sorry.
And we're quite a lot therefore hands on A, UK.
It's an indeterminate, indefinite, it is any old UK resident company. It's not a specific one.
Yes.
Now, the court may think to itself, well, Parliament should have made this clear. But the short answer is Parliament hasn't. And given the absence of any express rule, and we say the inability to imply a rule out of the direction in 1259, one then must apply the guidance we're given in For Women Scotland and Bank of Nigeria, but ultimately you are concerned with construing that the words Parliament has used. Now, at its highest, one might spell out of section 882 a purpose of not allowing transfers between economically related persons to engage the new regime. But you still have to decide whether you're concerned with transfers between economically related persons, where Parliament has defined that concept by reference to, quotes, related parties, and we say you can answer that question here, applying 882 to arrive at the conclusion that we are a 1B case and not a 1C case. Now, this difficulty, if difficulty it is, doesn't just arise in relation to 882 and the boundary rule. If you assume you've got IFAs that are created after the 1st of April 2002, so you're clearly inside the new regime, there is provision made for what are called tax-neutral transfers. So you transfer from one to another at the effective base cost so that the transfer itself doesn't give rise to a charge to tax. And you can have a transfer that's a tax-neutral transfer if you're within section 775, just for your note, it's authorities bundle, page 38. But that rule only applies if the transferor and the transferee are in the same group. And group is defined by reference to share capital. So if you have a transfer by a company to a partnership made up of itself and another, you still have to ask whether you've got a transfer that's tax neutral because they are members of the same group. And in order to answer that question, you have to follow 1259, that you're statutorily directed to assume the trade of the transferee is carried on by a UK resident company, but you're not told anything else about that UK resident company. Now, we accept in those circumstances that we would not be able to establish that that was a tax-neutral transfer because we could not say that the statutorily directed a UK resident company was in the same group as the transferor. So we are accepting the benefit and the burden of our argument. that the court should be alive to the fact that what you ultimately say about this case has wider amplifications than just section 882. Now, the decisions below, first if we look at the first tier first, it's core bundle page 122. You should find paragraph 107 in the first tier. So Judge Beer in the first tier sets out the parties' arguments at real length. That's not a criticism, but the bulk of his judgment is summarising the position of the parties. You've got quite a long way down before you get to his reasoning. What he does at paragraphs 107 to 109 is to reject any help from Bluecrest. And we say he was wrong about that.
Does it matter?
Well, ultimately in this court, no, because it was only the Upper Tribunal and you are the Court of Appeal. Paragraphs 111 to 114 reject an argument that Muller had not, I understand, advanced below. So we don't need to pay attention to those. But it's 117 onwards, 117 through to 123. Beginning at 116, we see some force in the appellant's submissions, and then they set them out. 117, each of the above points has given us pause for thought. On balance, we've concluded the second proposition is incorrect. And the reasons they give in subparagraph 1, they accept that what they call the first proposition might be wrong, but the second might be right. And they say at the end of sub 1, that seems to us to be neither a logical outcome nor the most natural reading. And then 2 is an expansion on that statement. And then the guts of their proposition number 2 is 6 lines down. In our view, it follows logically that where the defined term related parties appears in one of those computational provisions, it is entirely appropriate to make the same assumption in applying that defined term. In the present case, that means section 835 should apply in the context of 882 by reference to the notional company. So they're ascribing to what they call the notional company the real world attributes. And the justification, so then they discuss what they're not doing in sub 3, and then 4 refers to Marshall and Carr. But the justification ultimately is in their subsection 5, so paragraph 5. About 12 lines down, there's a sentence that begins 2/3 of the way across the page, that notional company. As the court sees that notional company in each case is a statutory fiction which represents the partnership as a whole. As such, the ownership characteristics of the notional company should be regarded as matching the ownership characteristics of the partnership. And that is said to be the effect of 1259 subsection 3. And we say the problem with that line of thinking is that it rests on the proposition that the actual ownership characteristics should be ascribed to the UK resident company because the resident company represents the partnership. And that carries with it the sense that one embodies the other. We say not right. The only statutory direction in 1259 is that the trade carried on by the LLP is assumed to be carried on by the UK resident company. Now, the Upper Tribunal appear to say two slightly different things. Page 56 of the core bundle, picking the Upper Tribunal up at paragraph 43. That first sentence of paragraph 43 appears to justify the conclusion the Upper Tribunal eventually reaches on the basis that there is a provision that treats the partnership as if it were a company. That's 5 lines down in that paragraph. Now, if that is what the Upper Tribunal meant, it's wrong. It's not the effect of 1259 subsection 3. That goes beyond the statutory direction. Now, the second way that they put it is from paragraph 44 onwards, dealing with what Mr. Trevor had said below. 5 lines down, having summarised his position, they say in our view that misses the point. The task is to see if the control requirements are satisfied, which is possible in respect of a partnership given the broad way in which control is drafted. What matters is the outcome. So what they appear to do is to say, like the first here had said below, that the real world characteristics as between the transferor or members of the LLP and the LLP should be treated as applying to the UK resident company, because that is said to be the effect of the statutory direction in 1259 subsection 3. And we say that's not the effect, the court has my point, that's not the effect of 1259 subsection 3. It's not a necessary implication in order to ask the section 882 question or to answer it. So we're not saying you don't ask the 882 question. We positively aver that you do. We're not saying you can't answer it. We positively aver that you do. But you answer it with the conclusion that it's not an acquisition from a related party. Now, picking up on a point that my Lord Justice Lewison put to me a little while ago, the Upper Tribunals say, well, you have to take the course they did of assuming the actual control characteristics apply to a UK resident company in order to assume that it actually holds the IFAs in question. And that's the Upper Tribunal at paragraph 48. Now, the revenue in their skeleton argument accept that that's not right. This is paragraph 20.3 of my learned friend skeleton. He accepts that the directed assumption that you're carrying on this trade does extend to an assumption that your trade has these assets acquired on the date they were acquired. But my learned friend said, well, that's true. I interpolate true in our case, but it wouldn't deal with a world in which assets were acquired before the trade was carried on. And we say, well, there's nothing in this because here the assets were acquired on the day the trade was acquired. And if my learned friend is going to contend otherwise, that's addressed in paragraph 3 sub 4 of the first year decision, that the trades and the assets were transferred on the same day. That's core bundle 99. So it's not our case, it's not an answer to this appeal, but it's also a bad point because we know from section 1257 that this rule in 1259 applies to firms that carry on a trade or a business. So if you're carrying on a business but have not yet started to carry on a trade, these rules still apply. So we say that that observation in the Upper Tribunal at paragraph 48 is answered by the statutory directed assumption that you are carrying on this trade, having acquired these assets on the date that they were actually acquired. My low friends object to the outcome of this line of thinking by saying that Parliament can't have intended for the gateway of 882 to be always open, because that would allow what they call engineering. That's paragraph 20.2 of their skeleton. There are two answers to that. Firstly, that's not this case. We are not a case of engineering. But more fundamentally, what they call the gateway is not always open. Whether you are acquiring from a related party or not tells us whether you have to satisfy one condition, acquisition after the 1st of April 2002, or two conditions, acquisition after the 1st of April 2002 and meeting case A, case B, or case C. So in either world, you still have to satisfy the terms that Parliament has provided for as the boundary rule between the old regime and the new regime. My own friends can only really attempt to escape from that, we say, logical conclusion by ascribing to 1259 a purpose that takes on board some alleged intention of Parliament behind section 882. You have my submission that it's that sentence in paragraph 21 of my own friend's skeleton argument that gives the game away. So drawing those threads together, once one understands the true scope of the statutory direction in 1259, and one understands the purpose of section 882, and one recognizes that we are here applying 882, there is nothing inherently objectionable in an answer that this is not an acquisition from a related party. Parliament had not, before 2016, attempted to address this question. There's a separate debate about the effect of what happened in 2016, but prior to 2016, Parliament had simply just not addressed it. You say there is nothing in the language of the statutory code that would permit some implication of some additional term or condition that would prevent the application of 882 in the way that we've outlined. So that would be my fourth heading, unless I can help the court further on 882.
Thank you.
Takes me to my last and fifth heading. If we're right so far, did the law relevantly change in 2016? And the change that was made in 2016 that's most immediately relevant is section 52, which is at 22. Hoping might be 227, that may not be right.
210 in the hard copy.
Yeah, yeah.
I'm told it's 210 in the hard copy.
Yes.
So this is the Finance Act 2016, Part 2, heading Corporation Tax, Intangible Fixed Assets, heading Intangible Fixed Assets pre-FA 2002 assets. Chapter 16 of Part 8 is amended as follows. And then subsection 2, section 882 is amended by, after subsection 5, inserting 5 capital A to 5 capital D. Now we need to identify what changes are made and from when. First question, what changes are made? Well, the first change adds to what is meant by a related party. And the change is made in 5 capital A by introducing what's called the participation condition. The participation condition is 2 pages further back. So if we just turn this up, it should be 208. And this is a rule that applies to what's called transfer pricing for corporation tax purposes. And the transfer pricing regime applies if there's an appropriate relationship between 2 parties to a transaction. And that relationship is in part defined by the participation condition. And then the participation condition depends on whether you're concerned with financing arrangements or not, condition A or condition B. But each of condition A and B is expressed in terms of effectively participating in, amongst other things, the management of the other person. So it's broadening the notion that we have in the Act, Part 8 already, to bring in the participation condition notion of participating, amongst other things, in the management.
It seems a little odd at first sight that there's no signpost in 5A or indeed anywhere else in the section where you find out what the participation condition is.
5D, my lord, gives you the...
Oh, I beg your pardon, I'm so sorry, it's under my nose. Yeah.
So 5A imports the participation condition. 5D tells you where to find it.
Yeah.
So that's the first change that these rules make. And put slightly loosely, we're broadening the notion of what is meant by a related party. The second change is made by 5B, which is to tell us that in subsection 5A, now, rather oddly, it's in subsection 5A that this change is made. It's not in any other part of 882. But references in subsection 5A to a person include a firm. So person includes a firm. Otherwise, we would ordinarily look through firms to the members. Person includes a firm, but only in a case where, for section 1259 purposes, references in this section to a company are read as references to the firm. And that, it is common ground, is defective drafting for a reason I'll come to in a second. So first change is to introduce the participation condition. Second change is to treat person as including a firm in particular cases. It is common ground that if the other difficulties we're going to address in a second don't arise, and we look at the LLP itself, then the application of the participation condition would mean that the transferor is related to the LLP. And that's the FTT at 24 and the Upper Tribunal at 71. It's also common ground between the parties that 5B is in effect an air shot because it misdescribes the purpose and effect of 1259. So those are the changes that are made. When do these changes have effect? Well, that's provided in 52 subsection 5. Amendments made by this section have effect in relation to accounting periods beginning on or after 25th of November 2015. And subsection 6 tells us that if you've got an accounting period that straddles that date, then you split that accounting period before and after, and the rules apply to the bit that's after. That in effect ensures you've got a common starting date irrespective of the accounting date. So those changes apply to accounting periods to the extent that they fall after the 25th of November 2015, and that means after that date, the notion of a related party is broader. Now, just for your note, in case it becomes relevant, section 53 over the page at 212 makes materially identical changes to section 845 of the Corporation Tax Act. And that's a deemed market value rule. But in section 53(1 introduces capital 4A to capital 4D, and they are to like effect. I only say this for this reason, that whatever construction we're eventually going to come to on the provision introduced by section 52, in effect, you have to be satisfied it fits with section 53.
Yeah.
Now, my own friends rely in addressing the effect of this on the explanatory notes. Can I just invite you to turn up in the authorities bundle? Should be page 684. Tab 26. This is the note to what was then clause 48. The court will have this in mind, but the explanatory notes are not a replacement for statutory language. We also know they're not always accurate. And here they're not actually accurate. So just a number of points to note.
Can you just remind me who they're drafted by? They're drafted by the executive.
They are drafted, I think, by the Revenue's own counsel.
Yes.
The sponsoring department, I think.
Sponsoring
which-
department, yeah.
So in fact, I don't know.
It would either be the Treasury or HMRC.
My lord, yes. I don't know that it was the Revenue. It might be the Treasury.
But there's no input by parliamentary draftsmen.
Now, paragraph 1 talks in terms of clarifying the rules in part 8. Second sentence, this clause confirms. Now, it's implicit in that there's an assertion that they're making clear what they believe to be true anyway. But this court, by this stage of the argument, would have decided whether that's true or not. And I only get to this part of the argument if you're with me on the first part. So one can take the language of clarifying and confirming with a pinch of salt. It also says in I can't actually see the reference. If we go on to the yes, the background note, paragraph 11 of the note, again, the language there of confirming. It's talking about section 882, and paragraph 12 says these rules only apply to assets created on or after the 1st of April, or to assets acquired by a company from a third party after that date. Well, that misdescribes 882 because there are 3 possibilities in 882 and the notes only refer to 2 of them. So the notes are not quite accurate. There's an implication in the note that this is implicitly aimed at avoidance cases. Well, not our case. But all that the note makes clear is that there was an intention to widen the conditions for being in Part 8. We don't disagree with that. That was tolerably clearly the purpose of Parliament. But the question ultimately is what has Parliament actually done? So we say there are two reasons why there was no effective change in the law as regards my clients. First, we know that Section 52 imported the participation condition so as to expand the notion of related party in relation to accounting periods, any part of which fell after the 25th of November 2015. But Section 882, 1b, asks whether at the date of acquisition you have acquired from a related party. So even though in a post-November 2015 world, the question you're asking about related party is wider than the question you would have asked before, the notion of related party has a wider footprint, 882 still requires you to determine whether the parties are related at the date of acquisition. And Section 52 does not alter that. So what we have is a later change in the scope of the concept of related party. But the statutory directed question requires you to determine that at the date of acquisition, and our date of acquisition was the 1st of July 2013. Standing back for a moment, if X acquires from Y, when under the definition then in force they're not related, and the definition changes later and they would have been related if you apply the new definition, but you're only asking the question, are they related at the date of acquisition, then you have to ask and answer that question by reference to the law before it was amended. Now, the point is as short as that. But the Upper Tribunal said no. So paragraph 76, core bundle 62, perhaps it is just worth turning this up because foot of page 62, paragraph 76, the FTT reached the correct interpretation for broadly the right reasons. They say it's an annual tax. I'll come to that in a moment. And then 7 or 8 lines down on page 63, they say when the relief came to be applied, there would be no justification for applying the related party definition which applied at the date of acquisition, time of acquisition, because corporation tax was interested in the date of the debit sought to be given effect in order to determine the applicable law. It was not interested in the date of acquisition. I'm afraid, with respect, that's just flat wrong. Yes, corporation tax is an annual tax. Yes, you have to determine the debits in accounting periods after the 25th of November 2015. But 882 requires you to determine those debits by reference to the date of acquisition. So we don't disagree that corporation tax is an annual tax and you have to determine the debits in each year. And we don't disagree that you have to give effect to Part 8. And that Part 8 includes 882. But the effect of the change made by Parliament in 2016 is to broaden the notion of a related party by reference to accounting periods after the 25th of November, where you have a date of acquisition after that date. With respect to the tribunal below, we think that proposition really ought to be unarguable.
Yes.
if the court's with me on that, then the change that was made in FA 2016 doesn't apply to this appeal. If you're against me on that, the second point is what's the effect of the defective drafting in the introduced 5B?
Yeah.
And it is common ground that it is an air shot. It misdescribes or misunderstands 1259. And so what was said against us below, which the tribunals below have accepted, is that this is an Inco Europe case where the court can be, in the language, abundantly sure as to the purpose and intention of Parliament and the language that ought to have been adopted, such that this court can fill in that gap or blank in a way that constitutes interpretation and not legislation. Inco Europe is in the authorities bundle. Sure, I need to turn this up because you'll have it well in mind, but tab 16. 317 of live.
Yes.
And it's Lord Nichols. At page 323.
Yeah.
So it's that passage, hopefully sidelined between letters E and H. It's got the language of abundantly sure and then the 3 requirements.
Yes.
Now, here we say it is tolerably clear that Parliament intended to change the definition of related party so as to bring in the participation condition. It is tolerably clear it can be inferred that Parliament wanted to widen the conditions for being in Part 8. It's also tolerably clear that Parliament wanted to deal with partnerships, hence the reference to firm. But exactly what changes were to be made in the case of partnerships, we say, is not clear. Even if you assume that the participation condition is to be added, and it has to be applied to companies and to firms, there is no indication in the amendment that was made as to how you deal with a world in which you've got the 1259 statutorily directed assumption.
Isn't that a different point now? Those problems, if the reference as 1259 had been absolutely correct, this all applies where 1259 assumes that the trade of the partnership is carried on by a company, all the problems that you outline would still arise. There's nothing to do with that particular defective drafting. The points you're making, as I understand them, go to the whole of the amendments being made, not to the particular drafting mistake.
That latter proposition is true, but one has to test, I mean, my Lord has this in mind, but we have to test this in a world where the court is with me about the first part of the case.
I follow, but Inco Europe is looking at the particular drafting mistake.
Yes.
As we did in Pollen, as you will no doubt remember.
I'm going to come to Pollen in just a second, but yes. But even if one assumes the assumptions I've made so far about what was Parliament broadly trying to achieve, we're still not told by Parliament in the amendment that is made how to go about applying the participation condition.
That I understand, but as I say, it seems to me the same problems would arise if the drafting of the particular subsection had been absolutely accurate in describing section 1259. Well, I mean, what you're in effect saying is this was a silly thing for Parliament to have done.
Well, it's an inadequate thing.
Yes.
Parliament hasn't addressed.
Maybe, but that's what Parliament chose to do. And the tribunals and the courts will have to work out the consequences. It doesn't bear on the drafting mistake?
What I think my lord is putting to me is that one could correct the drafting mistake without necessarily having answered all of these difficulties.
Absolutely.
Because the difficulties arise in the application of the provision once corrected.
Yes, exactly.
I see the force in that, but one still has to determine that there is a form of words that this
Yeah.
court can in effect add in order to capture what you are abundantly sure was the purpose or the intention of Parliament. And I am saying in these circumstances, this court should not feel itself abundantly sure.
Right.
Now, perhaps if I just address pollen, it's in the authorities bundle.
It's the next tab.
It's the next, should be the next tab.
Yeah.
Should be at 325.
Yes.
The Lord will remember, but for the other members of the court, the problem in pollen was that the SDLT, stamp duty land tax legislation, did not obviously provide relief to charities on acquiring undivided shares in land. So you got relief as a charity, you didn't pay the tax if you acquired a freehold or a leasehold, but there was nothing expressly provided for the circumstance in which you might have acquired an undivided share with people who might not be charities. And there was no obvious reason for that wrinkle. My lord asked Ms. Tipples, who was then appearing for the commissioners, what policy rationale is there for this? And having taken instructions overnight, she came back and in effect said,
There isn't one.
there isn't one. I'm sure she put it better than that, but there wasn't one. And my lord, this court saw that as a clear error, which could be simply solved by inserting the words, in effect, to the extent that, to allow charities to get relief to the extent that their undivided share that they acquired was to be held for charitable purposes, even if other people acquiring shares at the same time were not holding for charitable purposes. So it was a simple solution to give effect to Parliament's clear intention. And this is not to belittle my lord's judgment, but the INCO criteria were readily, easily satisfied. It was a fairly straightforward application of INCO. And we say this case is just different because one can't be abundantly sure as to what wording ought to go in there to give effect to what the court perceives to be the intention of Parliament. Had Parliament wanted to answer this question, it could and should have amended 882 so as to make clear that when applying 1259, you apply the actual world characteristics to the relationship between the transferor and the statutorily directed UK resident company. But that wasn't done, nor is it contended by my learned friends that that is something that this court could do. And in our submission, that would be to cross that ill-defined but constitutionally important line between interpretation and legislation. Now, what do the revenues say about this? Well, on the first Section 52 issue, they say, well, you have to read the Act as a whole. We agree. They say the commencement provisions split the accounting periods which straddle the 25th of November so as to ensure that the new rule applies immediately. Well, we agree with that. They say that corporation tax is an annual tax. You need to work out whether this rule applies each time you address a debit. We agree with that. And they seek to draw something from Section 53, which has slightly different commencement rules, because Section 53 applies where you've got a transfer after. But what's noticeable is that that change that's made in Section 53 is not in Section 52. They're different rules dealing with different things, and so one is triggered by transfer after, and the other one is not concerned with the date of acquisition. So nothing we see in the revenue stance in this court would undermine the conclusion that we invite the court to reach, that the date of acquisition and the timing of the change is not something that is amended by section 52. And then on the second point, you have my observations about INCO.
Yeah.
Now, that's slightly faster than I had anticipated, unless I can help the court any further.
Thank you very much. Mr. Fitzpatrick, do you wish to add anything?
No, thank you.
Yes, Mr. Tibarsh.
My lords, would you just excuse me while I grab the lectern? Thank you. My lords, my lady, I am here with Mr. Abser and Mr. Rees. I'm going to take the first issue, i.e. section 882 and 1259. And my learned friend, Mr. Abser, is going to address you on the second issue, the Finance Act 2016 issue. The other thing I ought to say is that my learned friend has been quite careful to refer to a UK company. I find it quite a mouthful to say the a UK company. So I'm going to stick to the way it was referred to below, which is to call it the notional company. But please bear in mind by that I mean a UK company. I don't intend to infer any change of meaning. If I could open with just some general remarks. The first is a bit of a truism, but we say it should be borne in mind. Part 8 does not apply to a corporate member of a UK resident firm unless it applies by virtue of section 1259 subsection 3 in this case. That is, we say Part 8 applies only if section 1259 sub 3 has the effect that a UK resident company is treated as owning, I'm going to call them IFAs, intangible fixed assets, and as having created or acquired them in a way that passes through what I'm going to call the section 882 gateway. And so we say the two critical questions in this appeal are, one, can section 1259 have that effect? And two, does it have that effect on the facts of this case? Now, although it is probably true to say that it's common ground that both parties agree that section 1259 can have that effect, we do not agree about the basis for that. And that will require a little bit of looking at to see where we go. You have the appellant's assertion that the only assumption required is that the profits are to be determined on the basis that a UK resident company carried on the trade. And that the assumption that they were acquired in the trade means that they were acquired at the same time, that carried on the trade means they were acquired in the same way, at the same time, and by the same, and from the same person as they were actually acquired. We do not agree with that. And my learned friend refers to my paragraph 20, stop 3 of my skeleton. We did not intend to say that. We say fairly read, it doesn't say that.
I'm not sure that Mr. Peacock was arguing that the assumption was the assets are acquired at the same time and from the same persons.
That's what they say.
I think he's,
well,
I
that's
think
what they
he's
say
saying
as-
that we don't know who they were acquired from. And
Well-
therefore you can't say that.
Well, look, there might be a distinction here between what's in the skeleton and what was said in oral argument. In the skeleton, it was most definitely said that they were acquired at the same time from the same person. I'll turn that up. It's at paragraph 46 of their skeleton, my lord, which is page 220 of the core bundle. And you've
Yes.
just dealt in 45 with.
Yes, you're quite right.
Yes. So, my lord, we in turn will make 5 propositions. One reflects the wording of section 12593, which is that that subsection requires the profits of the corporate member to be determined on the basis that the UK resident company carried on the trade. That's fairly uncontentious. Proposition 2, the statutory purpose of section 1259 is to determine the profits of the firm on corporation tax principles. This includes answering the question whether Part 8 applies or not. Three, whether Part 8 applies requires answers to the questions posed by section 882, which I'll take you to in a moment. Four, on its proper construction, section 1259 requires that in answering those questions, all of the facts and circumstances surrounding the transactions carried out by the firm are taken into account. And as a subset of that, taking those matters into account requires it to be assumed that one, the assets were obtained by the notional company in the same way as they were obtained by the firm. And two, the notional company is controlled in the same way as the firm. And then 5, and I think this is, well, 5 is if that assumption is made, each of the corporate members is a related party in relation to the notional company and the appeal fails. as I understand my learned friend's submissions, there's nothing between us that if you ascribe the ownership characteristics of the LLP to the national company,
I think it's only really your fourth proposition which is controversial.
my lord, it is, yes. My lord, if perhaps we can just take this a little bit slowly, though, and just go back to proposition 1, that section 1259 requires the profits of the corporate member to be determined on the basis that a UK company carries on the trade. And if we just go back and look at section 1259, which I've used a copy at tab 6. I think my learned friend took you to a copy at tab 5. There's no difference between them. They're exactly the same. But just looking at tab 6, because that's the one I used. So page 177 of the bundle. And 1259 is a special provision, as my friend has informed your lordships, that applies if a firm carries on a trade and one of the partners in the firm is a company within the charged corporation tax, and that flows from subsection 1. And then subsection 2, for any accounting period of the firm, I'll come back to that, the amount of profit of the trade is taken to be the amount determined in relation to the partner in accordance with sub 3 or 4. In this case, it's sub 3 because the partners were UK resident. If the partner is UK resident, determine what will be the amount of the profits chargeable to corporation tax if a UK resident company carries on the trade, and take that amount to be the firm's profits. Now, if I could just turn to section 882, which I've got just a tab 3 of the authorities bundle, page 87. So, my lord, part 8 applies only if the direction to determine profits in section 12593 results in 1, IFAs that are IFAs of the company. You'll see that in subsection 1, the opening words. The general rule is this part.
Sorry, Mr. Tibbs, where are you?
Sorry, I'm in section 882.
882, yeah?
I'm on page 87.
Oh, I see, yes,
sub 1
fixed assets of a company,
of
yeah?
a company. So, in effect, I mean, the part 8 is actually quite sort of steps around the question of what "of" means, but it means either owns or has the use of. They've got to be of the company. But you'll see, you'll pick up under since one says they've either been created or acquired, they must have been either created or acquired, so they've either actually been created or the right to use them has been acquired. So in effect, it means that the company owns the IFAs or has the right to use them. And then little a says that 1, it must be shown that the IFAs were either created by the company on or after 1st April 2002, or B, they are acquired on or after that date from a person who at the time of acquisition is not a related party in relation to the company, or C, are acquired by the company on or after that date in case A, B, C from a person who at the time of acquisition is a related party. Now, in order for section 882 to apply, one's got to get within one or other of those subsections. You've got to say, well, I'm within A, or I'm within B, or I'm within C. It's not enough to say, well, you can see I'm not really within any of them. And as I will come back to in a moment, I say on the appellant's argument, they can't do that. Now, just while we're in part 8, could we just have a quick look at sections 712 and 713, which defines fixed assets, assets and fixed assets. They're on page 12. And you'll see section 712 under the heading basic definitions. In this part, intangible assets has the meaning it has for accounting purposes. In particular, intangible asset includes intellectual property and then sets out what it means by intellectual property, but includes patents, trademarks, etc. And then 713 defines what's meant by fixed. In this part, an intangible fixed asset in relation to a company means an intangible asset acquired or created by the company, so it's either acquired or created, for use on a continuing basis in the course of the company's activities. And I'll come back to the implications of that in a moment. But if you could just for completeness, if you could turn over and look at section 715. This part applies to goodwill as it applies to an intangible fixed asset. In this part, goodwill has the meaning for accounting purposes. So it applies to, it assumes goodwill into the class of intangible fixed assets and keeps them the same, treats them the same. So my lord, we say that intangible fixed assets are one, intangible assets which were acquired or created by the company, and two, which are fixed in the sense that they're used on a continuing basis in the course of the company's activities. So, my lord, that means assets which are exploited in order to generate a profit. It doesn't mean assets which are dealing or trading stock. And my lord, in this case, the material assets were brands, licenses, software, and goodwill. And I won't take you to that, my lord. That's the finding at first instance, which is at core divider 4, page 48, paragraph 8. Our second proposition, my lords, is that the statutory purpose of section 1259 is to determine the profits of the firm. That includes answering the question whether part 8 applies or not. And like my learned friend, I'm not going to take you to the authorities of statutory interpretation, which are well known. What I would just touch on Fowler. I wasn't too sure where my learned friend ended up on this because he said there was an arid dispute about whether it was a deeming provision. Then proceeded to rely on BCM to say, well, it's not really a deeming provision. But in any event, the answer, my lords, is as my Lord Justice Lewison said, is that it creates a fiction. And the law on creation of fictions is clear, is that you have to apply the fiction for the purpose for which it was created, and no more, no less. And that's what it says in Fowler. Whether you call it a deeming provision or not is really neither here nor there. And look, that point was emphasised in Bilter, where it was said both in the Court of Appeal and the House of Lords that one had to concentrate on the extent of the fiction and not take it any further. Now, just one point to notice on Bilter is that Bilter was concerned on the interrelationship between section 132 of the Insolvency Act, which dealt with the position where a company was restored to the register. And section 32 of the Limitation Act. And section 1032 said that where a company is restored, it is deemed to have been in existence from the moment it was struck off to the moment it's restored. And the question is, well, where did that take you? And that was the point at issue in the case. But the House of Lords approached the meaning of section 1032.
Supreme Court, in fact.
Pardon?
Supreme Court, in fact.
Sorry, my lord, I'm showing my age. The Supreme Court approached the construction section 1032, first by reading it and applying it, and secondly said, well, we should also have a look at a purpose of construction, and a purpose of construction results in the same thing. So they did it on those two bases. And so we say, when you're looking at 1259, you should be applying a purpose of construction, as well as just running your fingers under the line. So well, this brings us back to what we say the purpose was, which is to provide a mechanism for assessing the profits of the corporate member. And that requires an answer to whether Part 8 applies or not. And that leads us to our proposition 3. So look, we start then that the corporation tax calculation requires the questions posed by section 882 to be answered. Each of them needs to be answered yea or nay. Now, I was going to touch on the burden of proof here, but in exchange between my Lord Sir Launcelot Henderson and my learned friend said they didn't rely on the burden of proof. They accepted that the burden lay on the taxpayer. Well, we would say that it would be an unsatisfactory basis to decide this appeal on the basis of burden of proof, where you are, after all, applying the effect of a statutory direction. And it would be very odd if a statutory direction ended one up in a place where you couldn't say whether something applied or not. So we think in our submission, burden of proof is not really going to come into the equation here.
Well, I wonder.
Well,
it might be said that if you can't answer the question posed by section 882 and the burden is on you to satisfy or to show that you have passed through one of the gateways, then you simply fail.
Well, that is what we would say. The effect of 1259 is that it requires one to make certain assumptions or
yes, but
say
I mean,
certain things. And if the appellant cannot show that those assumptions answer the questions, yes, they will not be within Part 8. But we would say that's not a burden of proof, really. That's just an application of 1259. But if your lordship wants to put it as burden of proof, I'm happy to do it as a basis of burden of proof. And on the basis the burden is on the appellants to show that section 8, that each of the questions in section 882 is answered.
But I think the point is that if the section 259 fiction, let us call it, does not attribute any characteristics to this notional company, then that notional company cannot establish that it has passed through one of the gateways.
Quite so. Yes.
And
Yes,
that's not
whether
that's not burden of proof in the evidential sense.
No. But it's a legal burden in the sense they haven't satisfied
Yeah.
the statutory test. Yes, Lord.
Yes, I mean, the thing that prompted my question was, I think, a passage somewhere, I forget, in the Appellant's skeleton argument, where they talked in terms of the revenue having to establish.
It's footnote 3. It's footnote 3 on page, I think it's 4 or 5. They say because of the word "not," the burden's on us.
Yeah.
It's just not right.
Yeah.
So, my lord, we say little needs to be said. I've taken you to section 882 and outlined the questions, and there are essentially 3 questions there which need to be answered yea or nay. And those questions are: 1, if I can just summarise them, how did the company come to acquire the IFAs? Did it create them, or did it acquire them? If the company does own the IFAs, when did it create or acquire them? Three, if it's to be assumed that the notional companies acquired the IFAs, were they acquired from a party who is not a related party in relation to the firm? 4, were they acquired from an intermediary who is a related party? But they fall within one of the special cases A, B, or C. So well, that takes us to proposition 4, which is that in answering those questions, all the facts and circumstances surrounding the transactions carried out by the firm are taken into account. Now, if I could just take you back to section 1259 to have a look at that section. I'm again using the version behind tab 6 of the authorities bundle, page 177. And subsection 3 is beginning to look fairly familiar.
Sorry, where are you? Page?
Sorry, page 177.
Yes.
No, is it just because the print is bigger? So look at subsection 3. If the partner is UK resident, determine what would be the amount of the profits of the trade chargeable to corporation tax for that period, that is for the accounting period, if a UK resident company carried on the trade and. Now, my lord, we say that that can be interpreted in 2 ways. Either if the A company or the notional company is entirely hypothetical and ignoring all the surrounding facts. This is in effect the appellant's argument. We don't agree that it gets them to the place they want to get to, but that's the foundation of their argument. Or we say it can mean determine the profits chargeable to a company if a company which is not entirely hypothetical and takes into account all the facts and circumstances surrounding the transactions carried on by the firm, carried on the trade. So is this a wholly hypothetical company with no relationship to the real world? Or is it a company which does have a relationship to the real world? We say that second meaning is the correct meaning. We say that takes one on to two results. One, that the notional company acquired the material assets in the same way as they were actually acquired by the LLP. And two,
So in effect, you say, is this right, that the only change you make to the real world is that you apply corporation tax computational principles to the facts as they are in the real world?
yes. Yes, you're looking at it from a real world point of view rather than a wholly hypothetical point of view. And so, Lord, just to recap, we say, first of all, first results, the notional company acquired the material assets in the same way as they were actually acquired by the LLP in this case. And two, that the notional company was controlled in the same way as the LLP. And Lords, we have essentially two reasons for that. The first is what we say about the illogicality of the gateway always being open on the appellant's argument. We say that is a strong indication that the real world view is the correct one. Secondly, my lord,
So why is the appellant's argument illogical?
well, because on
Maybe
the-
undesirable
I'm
from your
sorry.
perspective, but why is it illogical?
I'm sorry, my lord. So on the appellant's argument, they say first of all they submitted below that section 882 is an anti-avoidance gateway. It's meant to stop transactions between entities which are related to each other, and there's no. It doesn't help appealing to the anti-avoidance section because as here, a transaction can be carried out with a view to saving tax without it actually having the purpose of avoiding tax. And so, as the appellant submitted below, section 882 has an anti-avoidance purpose, which is to avoid transactions being engineered between related entities. But on the appellant's argument, section 882 gateway is always open.
Yes, I see.
Well, I don't know whether this is a convenient
The
moment.
clock is 5 minutes fast, so you've got
Oh.
you've got 5 more
I've got
minutes
5
if
more
you
minutes.
want.
Excellent. Well, then I'll move on to my second point, which is a more fundamental one, if one likes. Is that if one applies the first meaning and on the appellant's argument, section 12593 does not direct any assumption at all as regard the IFAs, and Part 8 cannot apply.
I'm sorry, will you repeat that?
Yes,
On the
I'm-
appellant's assumptions, 12593,
does not direct any assumptions as regards the IFAs or the material assets. And Part 8 cannot apply. And to see that, my lord,
then that's because the notional landscape is a wasteland.
my lady, yes, I mean, it's because all that is directed is that that a company carried on the trade. Now, to carry on the trade, one only has to assume that it has the IFAs and it uses them in the course of that trade. It says nothing about whether they acquired them or they created them or when they were created or acquired. It says nothing at all about it. Carrying on trade,
I think that was the point I was putting to Mr. Peacock.
my lord, yes.
But I mean, you would accept that if they're selling yoghurt under the Muller brand, they've got the trademark, presumably.
They've obviously, they've plainly got the trademark, but what section 1259 requires, if you recall, is that in each
They've
accounting...
got to have acquired or created it after a particular date.
Yes, and well, both. They have to have acquired or created it, and section 1259 doesn't give us any clue at all if applied literally on a hypothetical basis, gives us no clue at all about whether it was acquired or created.
Yes, all you know is that they have it in a particular accounting period.
And they use it in the accounting period for their trade, and that's all that's required.
Yeah.
No more, no less.
Mhm.
And so that means that on our submission, that Part 8 just simply cannot apply, applying the first meaning or applying the appellant's arguments.
Yeah.
And so, look, we say that therefore on the appellant's argument, it runs into the sand. It simply can't get through the gateway, and Part 8 does not apply.
And they have to get through the gateway in order to get their deductions.
Precisely, my lord, yes.
So in a sense, it's they're trying to have their cake and eat it, aren't they? Or whatever cliche one likes to
Whatever
use.
cliche one likes to use. We were accused of what I might call cakeism ourselves in my learned friend's skeleton. But yes, we would say the same. We would say that they cannot at the same time assert that section 1259 is to be read in a wholly hypothetical sense, and also that they get through the gateway, because the one is inconsistent with the other.
Yeah. Is that the end of that point, Mr. Tidmarsh?
My lord, it is the end of that point.
Shall we break there, and we'll come back at 2 o'clock real time. It should be 2:05 by that clock.
Court rise in favour.
No, it wasn't. Just in case it did.
Apparently, yeah. That's my day. I need to mute it.
That's good to go and get a sandwich.
So we've got cafe and cafe. I can show you a sandwich. It's slightly quicker to get in there. So it's like,
It's okay, we can sort this out outside.
Trapped forever.
Yeah, exactly. Do
Interrupt us.
you want to just pull it if it's anyone's round?
Why is it the Court of Appeal insists on it?
There we go.
Everybody else does.
So you can speak.
High Court is rubbish.
No, High Court doesn't do it for
I'll
who
throw it
uses
off too short.
Oh, did it not normally? I did the JR where.
No wigs normally in the High Court except for certain things. So,
The only one I use is the JR for.
Right.
So they, I think JR is Queen's.
Yeah.
Queen's Bench.
They do wait. So it's the only cause we have now.
I think it's
to go
transfer
in.
division.
But I think you'll find there's some direction which will say basically no, but in all divisions, apart from things like
That's aggressive.
Hi there. Do I have 5 minutes just to clear this one?
Oh, I was told you.